have some news. On Tuesday the 22nd of June, the long-awaited security of payment legislation reforms finally passed the WA Parliament. I've been fielding heaps of questions from principals, head contractors and subcontractors about what it all means. And the first thing I want to say is don't pop the champagne corks just yet. Yes, it's officially passed the WA Parliament, but we're going to have to wait a while for the regulations to be drafted to make it all work in the real world, as in like probably 12-ish months. So definitely not time to tear up the old contracts yet. But seeing as the reforms have attracted a bit of attention in the wake of the Pindan collapse, I want to share the high points with you so that you know what to expect when it actually does hit the WA marketplace. If you're not in construction and you're wondering what I'm talking about, security payment legislation is the set of laws that attempts to protect the construction supply chain from unscrupulous behaviour from principals and head contractors. WA has had some protection since the mid-2000s in the Construction Contracts Act. However, the industry in some reviews, including the Fiocco report in 2018, said that those protections didn't go far enough. And so the McGowan Labor government committed to boosting up the WA system and bringing it more in line with other Australian jurisdictions. So here's the answers to the main questions that people have been asking me about what it means for their contracts and their business. The impact on adjudications, that's a topic for another day. Anyway, so here's 8 points about what it means for your business. Firstly, it won't be retrospective. The new Act will only apply to contracts that are signed after it comes into effect. It's going to reduce payment terms from 42 days to 20 business days, so effectively from 6 weeks to 4 weeks. It will confirm the time for submitting payment claims, which will basically be monthly, but there will be a 6-month deadline for submitting claims. Head contractors and principals are going to be required to issue a payment certificate within 15 business days of receiving a claim, and failure to issue a payment schedule certificate, whatever you want to call it, in that time means that the principal or the head contractor becomes liable to pay the claim. That means that the claim becomes a debt that can be enforced. Time bars against variation and EOT claims will not be able to be unfair or unreasonably onerous. Remains to be seen what that's actually going to mean in practice though. Principals and head contractors are going to have to give 5 business days notice before they exercise their rights to recourse to security. Cash retentions, they'll be deemed to be held on trust, and the party that holds them will be required to pay the retention money into a statutory trust account. So in a situation like Pindan, retention monies won't disappear into the air, they'll be able to be claimed. And last point, contractors and subcontractors will be able to suspend for non-payment after 2 business days notice. So that also might have helped a few businesses protect themselves as Pindan started to get into strife. So those are the eight points that I've taken from the reforms. Probably not as far as some subbies would have liked to go, especially the absence of project bank accounts, but you know, a little bit more protection than they had before. But you know, I'd love to hear what you think of the reforms. Let me know. Otherwise, thanks for watching and see you next time.